Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. Today's video comes to us from Accountability Media's channel. Be sure to check out their channel in the description below and give them the credit that they deserve. This episode covers regulations versus statutes, photography of military installations, and outdated legislation. Let's dive right in and audit the audit. On April 30th, 2019, Accountability Media attempted a First Amendment audit at the Joint Base Meier-Henderson Hall in Arlington, Virginia, where he was initially contacted and detained by Officer Daniel of the base police force pending the arrival of his superior.
Stand by.
Are you detaining me when you say stand by?
Say again?
Are you detaining me when you say stand by?
Yes, sir. Just stay right here.
Oh, you are detaining me?
Yes, so we can further have an investigation.
I'm just reaching for my phone, nothing else. It is 4:13 p.m. and JBMHH Police Officer Daniel.
Go ahead and give me one out here at this location.
Is detaining me?
So, do you have a reason you're videotaping an entrance to a military installation?
Not one that you need to know, sir.
Not one that I need to know.
So, what is your rank, sir?
Okay, just stand by. Just wait right here.
During the wait, MP Widman and Officer Lewis arrive on scene, conduct a Terry frisk, and attempt to question the auditor.
Why are you filming? You know it's a military base, right?
I'm on the public sidewalk.
Yeah, I know, but this is the gate function. You can't videotape the military base.
Is that the law, or is that just what you're saying right now?
Officer Lewis gives the auditor a verbal notice that he is not allowed to record the security checkpoint. This is important information for later in the video.
It's against federal regulation to film an ACP or an entry point.
It's not against federal law, sir.
I didn't say law, did I?
Right. So your regulations, whatever regulations apply to you on that installation, do not apply to me on this public sidewalk.
In order to grasp the full spectrum of legal nuance at play during this interaction, it is important to highlight the distinction between statutes and regulations. Laws passed by the legislature are generally known as statutes. Often, legislatures pass statutes that outline general guidelines and then, within that law, authorize agencies to nail down the specifics of the process and enforcement. Regulations are laws created by agencies and usually must be authorized by and are subordinate to statutes. If a law existed which broadly prohibited photographing or videoing military checkpoints, and the military had created regulations to enforce that law, then they would apply to the auditor and the general public. In this case, no such law exists.
I'm on public property and I'm not doing anything illegal. That's pretty much the start and end of that story.
Eventually, the acting supervisor, Staff Sergeant Hook, arrives and makes contact with the auditor.
Okay, sir. Well, allow me to see if I can answer your question. Okay. So there is a congressional letter that is out. I'm pretty sure you know which one I'm talking about. The congressional letter states that you can take pictures and video of a building structure and architect. However, you cannot take video or picture of a building access control point or an access control point to a military installation. And what this is an access control point to a military installation. However, with that being said, you can take video of the fence line, which is a structure.
Right.
You can take pictures over here of a structure, which is a wall, which is a structure. However, the report is that you're taking video of a access control point, which is against the congressional letter that is out.
Congressional letters are not legislation and hold no legal value. What Staff Sergeant Hook is likely referring to is the Operational Readiness Order originally issued by the U.S. Department of Homeland Security in 2010 and reissued in 2018. This order, which was disseminated to all Federal Protection Service personnel and officers, reiterates the 2010 guidance. It provides clarification on the public's right to photograph publicly accessible federal facility building entrances, lobbies, foyers, corridors, and auditoriums, and directs FPS law enforcement personnel to maintain security without adversely impacting the public's rights relating to photography and videotaping. The order clearly states that photography and videotaping, absent a criminal predicate, is a First Amendment protected activity. However, there is a clause in the order which grants an exception to areas where security regulations, rules, orders, or directives apply, pending that the prohibition is clearly posted or an actual in-person notice is given, which Officer Lewis did earlier in the video.
You
All right,
understand where I'm
so
coming from?
a congressional letter is not a piece of legislation.
This is where the legalities surrounding this interaction become fuzzy and harken back to a similar incident in 2014 involving two journalists from Toledo, Ohio's The Blade newspaper. On March 28, 2014, Blade photographer Jetta Frazier reportedly took photos of the Joint Systems Manufacturing Center in Lima, Ohio, while standing in a small roadway between a public street and the guard hut at the facility's entrance. When she tried to leave with Blade reporter Tyrell Linkhorn, military police detained and questioned them, confiscated their cameras, deleted their photos, and sent them on their way. Days later, the newspaper filed a federal lawsuit alleging that the military police had interfered with the journalists' lawful exercise of their First Amendment rights. The commanding officer of the facility declared that the MPs were acting lawfully, citing that it was against Army regulations to photograph the restricted base, but did not provide the specific regulations. The only relevant statute that the journalists could find which pertained to their case was 18 U.S. Code 795, which prohibits photographing or sketching certain military installations which the president deems vital. Military members often cite Code 795 as grounds for detaining civilians taking photos of military bases, but the law is often misrepresented and essentially only applies to areas and equipment which are already deemed classified. Under no circumstances does Code 795 grant the authority to create regulations which infringe upon citizens' First Amendment rights to public photography. The Blade eventually settled their lawsuit outside of the courtroom for a sum of $18,000 and likely surrendered a chance to challenge the constitutionality of Code 795.
When it comes to access control point, which is a security measure, you cannot take video or pictures of a security measure.
The security regulations exceptions which the Homeland Security's Operational Readiness Order refers to must be properly supported by coinciding statutes. It is likely that Code 795 would be the law cited to support any regulations which prohibit photography of a military security checkpoint from a public place. If Accountability Media were to file a lawsuit against the officers involved and the department as a whole, it would likely provide ample opportunity to challenge the constitutionality of Code 795. This code is an antiquated piece of legislation which fails to account for the proliferation of visual information and the public's right to create and access that information. Any person with access to the internet is able to view satellite images which display intimate details of the base's layout without ever leaving their home. An exact image of the gate which Accountability Media was filming is available on Google Maps. If challenged, there's a good chance that Code 795 would be ruled unconstitutional and either abolished or thoroughly rewritten.
Sir, when you are on public property, you can take video and pictures of anything you can see.
If you're on public property
Yes, it is.
or not.
It does.
After refusing to leave, the auditor is placed in handcuffs and put into the back of a patrol car for nearly 30 minutes, where he is eventually released by Detective Mitchell.
You don't have a public incident report that you're gonna file?
There will be a police journal entry that's done, which you can do a FOIA request, Freedom of Information Act
Right.
request.
I'm not sure if you're familiar
I've
with
done
that.
them before. Yeah.
Okay, you can do that if you want that type of information. Okay.
And
Could I possibly ask your name?
again, I'm not going to get that.
Okay.
And do you have reasonable articulable suspicion that I have committed and committing or about to commit a crime?
At this time, no.
Okay, then
said-
I'm not going to identify
Okay.
myself. Yeah, that was unacceptable. I'm sure that you guys are going to take corrective action against those officers that are involved. I'm sure you
Okay,
need
if
to
believe-
investigate.
If you believe that there was some type of unacceptable action,
I mean,
I would-
illegal
I would-
detainment to start
okay, I
out.
would encourage you. There is a joint.
Oh, I'll be filing complaints, I'm sure, and I might file a lawsuit. But, obviously, I'm just telling you, man to man, clearly you guys need to get your house in order.
Okay, there again. What do you mean by that?
I mean, you need to take corrective action because you cannot do that to people who are not committing a crime.
Can you be more specific?
You cannot pluck citizens up off a public sidewalk without any suspicion that they have committed a crime, detain them for over half an hour. It was probably 4:50 when you released me. I was detained at 4:13.
Well, to clarify, as soon as I saw that you were in custody,
I understood that you did that, but they did.
I released
Your police department,
Okay.
your police force. I assume it's not a department, but a force.
It's a department.
It's a department. Your police department illegally detained me for over 35 minutes with no reasonable articulable suspicion that I had committing, or was about to commit a crime. That's what I'm telling you.
Okay. Based off of what are you basing that off of?
Because you have told me there's no reasonable articulable suspicion.
At this
I was
time, I do not have any, but that does not mean that there
And
was
none of
no.
them were able to articulate any either when I asked them. They didn't tell me a crime I was being detained for.
Okay. Where's the legal precedent that we're required to do that?
To tell a citizen what they're being detained for?
Yes.
Detective Mitchell is correct. It is a common misconception that law enforcement officers are required to inform citizens of why they are being arrested or what probable cause led to their arrest or detainment. While it is true that officers must have reasonable and articulable suspicion that a crime has or is about to occur, there is no legal precedent which has established a citizen's rights to know why they are being detained or arrested.
You have to have reasonable articulable suspicion that
But
and
we
you
don't
need
have to explain that to that person at that time.
you
So
generally need
I
to
am not,
articulate
I'm not going
that.
to further debate.
Well, they
with
said
you
they
here.
don't have reasonable. They didn't say they couldn't produce the law. They said they didn't have reasonable
Okay.
articulable
So,
suspicion.
at this time, I'm not going to further argue with
yeah,
you.
I don't
about it.
need
All
to
right.
stand here arguing with you either. I'm just trying to tell you, I'm going to take my own action to follow up on this, but I would highly recommend that you take corrective action as well. You too.
Overall, Accountability Media gets an A for standing his ground and not allowing the flawed logic of the officers to infringe upon his constitutionally protected rights. I sincerely hope that Accountability Media follows up this encounter with legal action and ultimately challenges the constitutionality of Code 795. It would be great to see Code 795 struck down and replaced with a more modern statute which accurately balances the right of public photography with the security of military installations. Officer Daniel, Officer Lewis, and MP Widman all get a C-. It has become standard practice among members of the military to wield Code 795 as a weapon to detain public photographers, and these officers followed suit. Although they did not specifically cite the code, it is fairly safe to speculate that Code 795 was the root of why they detained the auditor. None of these officers were properly informed on the laws they were using to detain the auditor. However, They also did not go out of their way to violate the auditor's rights. Staff Sergeant Hook gets an F for completely fabricating the language of a congressional letter and detaining the auditor on the basis of a document that doesn't even exist or hold any legal merit. Anyone in a supervisory position should be well versed on the rights of citizens and the limits of their authority. If Staff Sergeant Hook serves as an example of the leadership among the officers of the JBMHH Police Department, then it is no surprise that his subordinates are misinformed. Detective Mitchell gets an A- for immediately releasing the auditor from the detention of the other officers, engaging in a dialogue with the auditor, and instructing the auditor on the proper channels to retrieve the information he was requesting. Let us know if there's a video you would like us to audit or a topic you would like us to discuss in the comments below, and don't forget to like and subscribe for more police interaction content.